Okay, today is October 19th. This is BA 230 Fall 2021, and we're going to be talking about jurisdiction and the court system in the United States. So let's start off on page 19. All right, so today we're going to talk about jurisdiction and the court systems that we have here in the United States at various different levels. And I want to start off with this word jurisdiction. So, actually I want to go background a little bit farther. How many courts do you think we have in the United States? I mean, courts. And I'll give you an example of what I'm talking about.
Like court systems?
Yeah.
I would say about 3 levels.
Well, sort of, yeah, 3 levels. I'm talking about the actual individual number of courts.
Individual, I wouldn't know.
Yeah, I'm not sure I know either. So let me give you an example of what I'm talking about and why this matters. So I'm a practicing attorney. One of the things I do on behalf of my clients, if they've been harmed or damaged or injured, or if they have a breach of contract or some other type of situation involving a case where I have to file a lawsuit. Part of my job is to prepare the court paperwork to file, to start the lawsuit. It's called a complaint or a petition, depending on the type of case. And then I write that all up on behalf of my client, and then I have to file it in the correct court. If I don't file it in the correct court, then the court's going to throw it out because it's in the wrong court. There's lack of jurisdiction, which we'll get to in a minute. So I have to determine which is the correct court to file the lawsuit. It's part of my job as a lawyer. Or on the flip side, if I'm representing a client that has been sued or charged with a crime, I have to make a determination when I'm defending them and representing them on their behalf whether or not the lawsuit or the criminal case was filed in the correct court. Because if it was not filed in the correct court, then I'm, on behalf of my client, I'm going to file what's called a motion to dismiss because it's the wrong court. So to give you an idea of the scope of the issue, the problem, I want to talk about how many courts there are. So this is on page 21, and we'll come back to this in a little bit, but just to give you some idea, this is a map, of course, of the United States, and basically this is a map, this is out of the textbook, that shows the federal court system kind of in a breakdown. So the way it works is, back to your answer, we do have various different levels. We have federal courts, we have state courts, and we also have courts at the county level and at the city level, and then various other type of administrative judges, not really a court, but they also have hearings. So to give you some idea of how many courts we have, in the federal system, each state has at least one court, one federal court. It's called a federal district court. And some states have more than one federal district. Oregon only has one, but Washington, for example, has 2, the western and the eastern districts. California, because of population, has 4 federal court districts. And so if we have 50 states around the United States, each state has at least one federal court, some states up to 4. Then if you multiply that all out, basically we come up with, if I remember correctly, 94 federal courts, what are called district courts. That's the first level. Then at the next level, we have what are called courts of appeal. That's where you go if you lose in the lower court. You go to the higher level court, which is an appellate court. We'll talk about that more in a minute. And so that's what these dots are right here that have numbers on them. Those are federal circuit courts of appeal. And again, I'll get into that more detail in a few minutes. So there are 11 dots on here, if you see. And in addition to that, there are 2 additional federal circuits in Washington, D.C., and also, which is the D.C. Circuit, and also the Federal Circuit Court of Appeals, which is also in Washington, D.C. So there's actually 13 federal courts of appeal. And then on top of that, we have the U.S. Supreme Court, of course, which there's only one. So what's that, 107, 108 more or less federal courts. And that's actually low because there's also tax court and military tribunals and other types of federal courts, which we won't get into here. But just for today, so about 108. So not a huge amount, but still there's enough there that I have to figure out, where to file a lawsuit. All right, well that's the easy one. Let's flip over one more page. Look at this map. A little different scenario now. You know what that's a map of? United States, of course, but broken down by what?
Counties?
By county, correct, by county. Real quick, each of these is a county. Why don't you guys go ahead and count those up for me real fast? Just let me know how many there are. Any guesses? Anyone? Bueller? About 3,000 counties, if you add them all up among the 50 states. So the reason I show you that map is, on the most part, and I don't know this is totally true, but for the most part, every county is going to have at least one court system within that county. Some counties are going to have more and some less. So here we are in Polk County, right over here. Relative to East Coast counties, they're much smaller. The counties in the west are much bigger because more land mass. So we're in Polk County. Here in Polk County, we actually have several court systems. We have our state circuit court, which is located in Dallas, which is the circuit court for Polk County for the state of Oregon. We also have a court in Monmouth. Some of you may have been there if you got a traffic ticket or something in Monmouth. We have a city court, that's a municipal court or a city court in Monmouth. We have a court in Independence, Oregon, which is a municipal court as well for same type of thing, traffic violations or zoning or nuisance or other type of violations of city code. We have a municipal court in Dallas. So there are 4 basic court systems within Polk County alone. So if you multiply that out, let's just say on average there's 2 per county across the United States. That's about 6,000 courts. And then on top of that, within each court system, you're going to have multiple judges, multiple courtrooms. So here in Polk County, we have 3. Multnomah County, if I recall, has about 100 judges, so 100 different courts within Multnomah County. So literally, there are tens of thousands of potential courts where I have to file potentially my lawsuit. So let me give you an idea what I'm talking about. So let me just give you some kind of a scenario what I'm talking about. So let's say I represent a client that is going to open a new restaurant. I'm going to go back to this other page, make it a little bit easier. So let's say I'm representing a client that is opening a new restaurant in Boise. They're headquartered in Oregon. Let's say they have restaurants throughout the West, sort of a semi-chain. And as part of that, they're going to lease property there in Boise. They're going to build out their restaurant. And the client goes to Orlando for a convention for restaurant supply companies. And at the convention in Orlando, Florida, they enter into a contract to purchase all of the kitchen equipment to put into the new restaurant. And so they say that equipment is going to be manufactured by a company headquartered out of Illinois, and it's going to be actually manufactured in Detroit, Michigan, and then it's going to be shipped by semi-truck or by train to Boise, Idaho, where it's then going to be installed by a construction company that's headquartered out of Utah. And so they install all the equipment, they have opening night at the restaurant, and a big fire breaks out. And let's say people are killed because of the fire, patrons. So it's horrible. So now my client is going to get sued. So let's say the people that were killed, one of them is from Arkansas and one of them is from Arizona. They're in Boise visiting or whatever, it doesn't really matter. So we have an Oregon company with a location in Boise, signed a contract in Florida, equipment company that manufactured the equipment that potentially caused the fires, headquartered in Illinois. It was manufactured in Michigan. It was shipped out to Idaho by a company, a trucking company headquartered in Arkansas, installed by a construction company out of Utah. all right? Like, what? What does all that matter? So let's say the people that are injured filed the lawsuit in, the one that was injured that lives in Arizona filed in Arizona. Fire happened in Boise, Idaho. Now let's say the cause of the fire is in dispute. It's potentially due to faulty equipment that was manufactured by the Michigan company. It may have been caused by the faulty construction from the Utah construction company, or it may have been the fault of the staff in Boise because they weren't using the equipment right. That's yet to be determined. And everybody's pointing fingers at each other. Not my fault. So now we have multiple states involved. So how do we figure out, okay, the first lawsuit was filed in Arizona because the person that died is a resident of Arizona. So they filed a lawsuit there against my client, the construction company, the trucking company, the manufacturing company, and the staff. All of those people are brought into the lawsuit. So now I have to analyze that. Is Arizona the proper court to file that lawsuit? And so that's one of the things I have to do as a lawyer, is make a determination based upon the information, the facts. Is this the proper court? So to be able to break it down, out of all of these thousands of courts that we have potentially in the United States, we have to go through a calculus to determine if there is jurisdiction in that particular court. All right, so the jurisdiction calculation. That brings us back to page 19. So you can see here, 100% list 4. This is a fill-in-the-blank question that'll be on the midterm. What are 4 types of jurisdiction? There are 10 of them that we're going to talk about. 10 different types of jurisdiction. So first of all, what is jurisdiction? I'm going to highlight the word juris right there. Blow that up a little bit. Okay, so juris. Last class we looked at a similar word, jurisprudence. If you'll remember, that's the theory of law. Juris being law, or the doctrine of law. In this case, juris, law. And then we have diction. What is diction? To dictate. To speak, right? So, to speak the law. It's kind of a way of breaking that word down in everyday language. Well, that's sort of what it means. The word jurisdiction applies to all 3 branches of government, the legislative, the executive, and the judicial. And jurisdiction, basically, to speak the law, is a word that refers to the authority of a part of government to either make law, legislate, enforce the law, police, or, in the case of the judicial branch, a court. So jurisdiction refers to the authority at all 3 branches of government to engage in that area. And it refers to, for example, at the federal level, at the legislative branch, what authority level or in what areas can the federal government legislate? What areas can the federal government not legislate? Some areas are reserved to the states under the 10th Amendment. Now, we're not going to talk about legislative jurisdiction so much in this class. Same thing with executive. We're not going to really get into that as much. But within the executive branch, when we talk about jurisdiction, we talk about what geographical area does the executive branch have authority to enforce the law. So if it's city police for Monmouth, it's the city geographical boundaries of Monmouth, with some exception because there's cross-jurisdiction agreements with Independence and Polk County. But the idea of jurisdiction is the authority to engage in that area of law within a geographical boundary. Of course, at the federal level, it's the whole United States, right? So we're going to refer to and focus on jurisdiction within the judicial branch. So when I talk about jurisdiction within the judicial branch, I'm talking about what is the authority of a particular court, a judge within a court, to handle a particular type of case, to speak the law. In other words, does this court located in Phoenix, Arizona, have jurisdiction to handle this particular case, to speak the law? If a court does not have jurisdiction, if it does not meet the various calculations that we're going to go through here, then it is the wrong court, and the court does not have the authority to handle the case. In other words, even if the judge had a trial and made a decision, if the judge did not have jurisdiction, that court decision has no legal foundation. It's null and void. It's unconstitutional because the court did not have the legal authority to handle that particular type of case, or because the case was filed in the wrong geographical location. Okay? So there's a multi-part test. So let's start working our way through the different types of jurisdiction and sort of the math that, if you will, I'm not a big math person, that's why I went into law, right? My undergrad's in economics, and then I wanted to get a PhD in econ, and then I had to start doing this thing called calculus, and it had sigma this and sigma that, and derivatives, and math, icky. So I hire people to do that now. So the idea of jurisdiction, though, is kind of like math. You go through this equation, and if they all match up together, then yes, the court does have jurisdiction. All right, so let's start at the very beginning with these first two types of jurisdiction. And I will test you on this for sure, fill in the blank, and also multiple choice, or true, false. So, out of all of these thousands of courts that we have, all of the courts are going to fall into one of two basic categories: trial court versus appellate court. A trial court versus an appellate court. And these two types of courts are fundamentally different in terms of what their role in a lawsuit is and their role within the court system. So let's start with a trial court. A trial court is, as the name says, the place where a trial will be held, which I'll get into more in a minute. What is a trial? But the first thing I want you to understand about a trial court is it's a court of original jurisdiction. Original jurisdiction. Now that term original jurisdiction means originate, to begin, right? The first place. An original is the first one of a type or whatever. The origin, however you want to say it. So original jurisdiction is a phrase that means that is the court where a lawsuit must first be filed. You have to start either a criminal or a civil case in a court of original jurisdiction. The court must have the authority to be the first court that you can start a case before you start working your way up the ladder of higher level courts. So a trial court, by definition, is a court of original jurisdiction. Now in the real world, sometimes the U.S. Supreme Court has original jurisdiction. We're not going to get into that in this class. For purposes of this class, especially in civil court cases, we're talking about a trial court at some level: city, state, county, or federal. So the first thing I want you to know, or this is actually the second type of jurisdiction. First is trial court jurisdiction. A trial court is a court of original jurisdiction. That means that is where I have to start a lawsuit by filing it in a trial court within the proper location. So if I file, the idea, it's kind of like the upside down funnel. If I file my lawsuit in a higher level court, like an appellate court or a Supreme Court, the court's going to throw it out because it's not a court of original jurisdiction. It's an appellate court. And we'll get more into appellate courts in a minute, but basically the job of an appellate court in a nutshell is to review what happened at a lower level court, starting with the trial court, to make sure the judge made the correct decisions. Okay. So, a court of original jurisdiction means that a case must begin in that type of court. So the first thing I know is, all right, if a lawsuit has been filed, I have to make sure that the court that it was filed in is a trial court. It's a court of original jurisdiction. So that's pretty straightforward. All right. Next, the trial court is where you're going to hold the trial. Now, what is a trial? A trial is a hearing. You may have a jury trial where you have a jury with 12 people or 6 people, depending on the type of case. A misdemeanor in Oregon is 6 people. A felony in a criminal case is 12 people. Most jury trials in civil court are going to be 12 people. And that'll vary from place to place. But the idea of a trial is 2 things are going to take place in a trial. 2 types of issues will be resolved or determined in a trial. Or questions, if you will. The first is questions of fact. Disputes over factual issues will be determined at a trial. Now, when I talk about issues of fact, we're talking about who, what, where, why, and when, right? So who? The identity of a person. Is the person that's accused of the crime the person that committed the crime? That's an issue of fact. And it may be a dispute about whether or not it is the correct person. Were they picked out in a lineup? Is the videotape a picture of a video of the person or somebody that looks like them? So who? What happened? What were the facts surrounding the murder? What was the weapon involved? Where did it occur? Who caused it? You know, Colonel Mustard in the dining room with the candlestick. You guys ever play that game? Clue? Do they even have that anymore? Probably digital version now, right? Or Mysterium is the new one, right? So the idea of what happened, where did it happen, when did it happen, how did it happen? Those are all issues of fact, okay? We'll come back to that in a moment. The other type of issue is an issue of law or questions of law. Now, when I talk about a question of law, that might be, for example, is the law that is the basis for the lawsuit constitutional or not? Was the law properly legislated? Is the law preempted by a higher level law? Or that's for a judge to decide. Was there, or is the law legal? Is it constitutional? Is it preempted? Other issues of law would be something like, did the police have to have a search warrant when they searched, let's say, the trunk of a car after they pulled somebody over for running a red light? Or did they have to have a search warrant to do that or not? That's a question of law under the Fourth Amendment. And so a judge will have to make a decision on whether or not a police officer engaged in a legal search and seizure under the Fourth Amendment of the U.S. Constitution and the Oregon Constitution. That's a question of law as well. So we have 2 types of questions. Question of fact and a question of law. Questions of fact and questions of law. Both of those issues will be determined during a trial, all right? So that's one of the roles of a judge, a trial court judge, is to hold a trial and to make decisions of law and also to have factual decisions proven in court. All right. So, questions of fact. How do you prove a question of fact? So let's say identity. How do you prove the identity of a person? Can you give me some examples?
Check their ID.
What was it?
Check their ID.
Yeah, their identification, right? So they left their driver's license at the scene of the burglary. Oops. That's one way. Assuming it's not a fake ID, but then that's also a question of fact. Is it fake or true? All right. Fingerprints, right?
Yeah.
Yeah, what's the best way to prove identity scientifically? DNA, absolutely, right? And even it can be fallible, but that's mostly due to how it's tested, not so much the test itself, how it's collected, the samples, chain of custody, and all that. So those are all questions of fact. Who? What? What was the murder weapon? When? What was the date? Who, what, where, why, when, all those. So what I'm leading up to is questions of fact are proven during a trial by introducing evidence. This word right here, evidence. This is one of the most important sentences on this page. Evidence is how you prove a fact. So DNA. How the DNA was collected and all of that, was it collected properly without a search warrant? That would be a question of law. The results of the DNA test, assuming it was done properly, would be a question of fact. So identity, all of those questions of fact, we're talking about evidence. So evidence can only come in to the record during a trial. So if I'm the attorney for the plaintiff's attorney, I brought the lawsuit, my job is to prove the facts that I have alleged, that I state in my viewpoint occurred. So I have the obligation as the plaintiff's lawyer in a civil lawsuit, or in a criminal case, I'm the prosecutor. That's what I used to be, a deputy district attorney. I was a prosecutor. So my job was to produce sufficient evidence to convict somebody of the crime for which they've been accused. And if I didn't produce sufficient evidence, then I lost my case, and the person was found not guilty. So the job of the plaintiff's lawyer or the prosecutor in a criminal case is to prove their case through evidence. So what do I mean by evidence? Witness testimony. I will bring in witnesses to the crime or the automobile accident or the contract, whatever the case may be. Have them testify. Other types of evidence, of course, computer information, emails, metadata, all the type of computer documents that we have. That can all be evidence. Blood samples, DNA samples, drug tests, expert witness testimony. Maybe it's a medical malpractice case, and the issue is whether a doctor performed the proper procedures during surgery. That's expert witness, so we'll have other doctors come in that are experts. Tax returns, 911 calls, CPA records, QuickBooks, police reports, medical reports, x-rays. You get the idea, right? Videotapes, surveillance footage. Excuse me, got a tickle in my throat. Okay, so all of those kinds of things are evidence. That's part of the role of the lawyer before the trial ever begins, is to gather and investigate what evidence there might be, and we'll talk about how that occurs later. It's called discovery, and we'll talk about that later on, probably on Thursday. So the idea of a trial court, and I cannot emphasize this enough, the only time that evidence can be produced or put into the record is during a trial. And that's one of the jobs of a trial court judge, is to make sure that the evidence, the proposed evidence, is in fact legitimate and can be admitted and provided to the jury. So maybe, for example, it's a photograph. Now, it used to not be this way so much. I mean, if you took a picture, on good old film, it was hard to manipulate that. Of course, nowadays we have Photoshop and all the editing programs and deep fake videos. So it's really kind of hard sometimes to determine, okay, is this a legitimate, real, true photograph? And so one of the things a lawyer has to do, if I'm submitting a photograph into evidence, I have to, it's called lay a foundation. I have to have a witness that can testify that that photograph accurately depicts what they saw, or if they're the one that took the photograph, what were the background, when did you take it, did you manipulate it at all, that kind of thing. And a judge will have to review that. Same thing with a blood test. How was the blood collected? Was it put into a vial? Was it properly marked? Was it stored correctly? Were there contaminants in the blood? All of those kind of things. So that is all determined during a trial. On appeal, no new evidence can be presented. All right? It is not the job of an appellate court to have new evidence presented. Evidence must come in during the trial. And so sometimes I get this question. I'll have a client that wants to sue somebody, and I say, okay, well, we really need to hire an expert here to testify, but it's going to cost $5,000 to $10,000 to pay them. They're expensive. Well, why don't we just hold off on that, and if we lose on appeal, we'll do it. No, it doesn't work that way. You have to present the evidence during the trial, or you don't have that opportunity later on. Now, there are times when if new evidence is discovered, that can come into the situation, but I'll talk about that later, okay? So, the only time evidence comes in is during a trial, not on appeal. The way that it works is the trial court will create what's called a record, and that will be the evidence. So if it's a witness testifying, all of their words are recorded, and then they're written down by a court reporter who will then publish it into, they'll type it out and print it. And so all of the testimony of a witness during a trial is recorded and typed up. All the photographs are put into evidence, videotape, all that stuff. And then if it goes to appeal, it's all boxed up, or nowadays it's digitized and emailed. And so you send it to the appellate court. They're not going to have new evidence on appeal. They will review what happened during trial. So I'm going to make kind of a comparison between football, between a trial court and an appellate court in that respect. And not just football, any kind of sport where you have video replay, right? So the trial would be equivalent to the game itself. So let's say it's first down, 1st and 10, and the quarterback throws the ball and it's caught, and the question is, was the receiver in bounds or not when they caught the ball? So that's all recorded on video. The field, depending on the type of game, so the field judge or the umpire or the referee makes a determination that yes, it was a catch. The receiver was in bounds, had possession of the ball. And so that's the decision on the field, right? So that would be, the gameplay itself would be the evidence, the facts. The decision by the judge or the umpire or the referee in the game at the time, that would be like the decision of a trial court judge. Now, it's going to get reviewed. So then it goes to the video booth upstairs, let's say. That's going to be like the appellate court. They don't run the play over again. They watch the video of the play that occurred from multiple angles. That's the evidence of the trial, if you will, the game. And so they're going to make a decision in the video booth upstairs, just like an appellate court. They're not going to have a new game or a new play. They're going to watch what happened and decide, did the referee in the game or the umpire or whatever, did they make the right decision? If not, they'll overturn it. If they did, they'll affirm it. Or if they can't decide, they'll just leave it as is. Same kind of thing happens in the law. So the game itself is the evidence. It's like the trial. The decision on the field is like the trial court judge. And then when it goes up on review, that's like an appellate court. And it might even be reviewed again after the game is over with by, maybe the Pac-12 commissioners or an NFL by the owners or something on more of a systemic level. All right, so the main couple things I want to reiterate about a trial court. Questions of fact, questions of law. Both type of issues will be decided in a trial court. Questions of fact are proven through the use of evidence. Evidence, such as witnesses or whatever, can only come in during the trial. Now, real world, let's say that there's a trial and somebody's convicted. Let's say it's a criminal case or even civil, it doesn't really matter. And then 2 years later we find out that, there's DNA now that we found that proves that the person that committed the crime is not truly the one convicted. That's new evidence. There is a procedure for that new evidence to be reviewed and to overturn the trial. Okay, so just don't, that there is that procedure, but it gets kind of complicated. I don't want to get into it here. Main thing is I want you guys to understand the trial court is where you start the lawsuit or the criminal case, and that's where you provide or have evidence proven in court. That's where you have witnesses and all that. An appellate court is not going to have new evidence. They're going to review what happened below and make a decision. All right, so the next type of jurisdiction is appellate court jurisdiction. So the basic job, just like I've said, of the appellate court is to review the decisions of the judge in the trial court or the lower court, I should say. Did the judge make the correct decisions during the trial? So this would be things like, for example, during a trial, if you ever watch TV, a lawyer will stand up and say, "Your Honor, I object." Well, we have what's called evidence code, and that is the law of how a trial is conducted. If you go to law school, it's a whole year-long class, actually 2 years, kind of. And the idea is there are rules about how questions can be asked during a trial by a lawyer, how evidence is presented, and you have to follow all these rules. They're very, very intricate. And so a judge, when an objection is made, so maybe I object, "Your Honor, that's hearsay." And when I object in court as the lawyer, I'm asking a judge to make a decision about whether or not the witness can make those kind of statements. Hearsay is basically second-hand information. You didn't actually witness what happened, you overheard somebody who did. So it's kind of like gossip, right? It's second-hand verbal information. And that's typically not admissible in court. You have to have the person who actually made the statement or saw what happened be a witness. Now there are exceptions to that, it's very intricate. But the idea is, in a trial, if I make an objection that's not relevant, that's hearsay, it's a leading question, a judge is going to make a decision, yes or no. Is the evidence of the blood test, was it properly done? The judge will make a decision at trial. On appeal, the court's going to decide, did the judge make the correct decision? Maybe the judge ignored a problem with the blood test and should never have admitted it into evidence. And if that's the case, then the whole trial is going to get thrown out. So that's the job of an appellate court, to review the decision of a lower court, a trial court or a lower court. Only questions of law will be determined in an appellate court. You're not going to have questions of fact. Those issues were already decided during the trial. That's what I mean by evidence can only come in during a trial. No new evidence on appeal. If you ever go to, if you're ever bored, well, with COVID, they're kind of limiting this, but eventually, courts are typically open, except for juvenile cases and some kind of cases like that. You can go watch trials over in Polk County and at the Polk County Courthouse. And if you go into the court, you'll see that the trial court is set up for evidence. You have a witness stand, you have a place for the jury, it's called the jury box, you have tables for the lawyers, and so it's set up for, they'll have screens and all this just like we have in a classroom to produce evidence. If you go to an appellate court, it's not that way. They got a big bench where the judges sit, and there's no witness stand, there's no jury box, because you don't have juries, you don't have evidence in an appeal. Well, I forgot to talk about this. A jury or a court trial. So, in a criminal case, you have a right to a jury, always. In a civil case, sometimes you have a right to a jury. Some cases you don't, depending on the type of case. But you also have the ability, if you have the right to a jury, if you're accused of a crime, you may decide you don't want a jury. You can waive the jury. In that case, it's called a court trial instead of a jury trial. That is, the judge will make the decisions instead of a jury. In a jury trial, the jury will decide the factual issues and the judge will decide the legal issues. All right. So, 3 types of jurisdiction so far. The first is original jurisdiction. The second is trial court jurisdiction. The third is appellate court jurisdiction. So now I'm going to file my lawsuit. I know that I need to file it in a trial court that has original jurisdiction. So that's what I'm going to focus on, all these thousands of courts. I'm going to focus on looking for what is the correct trial court. All right, the next 2 types of jurisdiction. Exclusive jurisdiction versus concurrent jurisdiction. Exclusive, of course, means only one. Concurrent means at the same time. In other words, you have more than one court that has jurisdiction. And this actually happens quite frequently. So for example, exclusive jurisdiction, only one court in all of the United States, or all the world for that matter, can handle that case. So an example of that would be, let's say bankruptcy. Let's say I can't pay my debt, and so I file for bankruptcy to have my debt either totally wiped out or reduced and put into monthly payments. That can only be filed in a bankruptcy court where I live, where I'm a resident. I cannot file a bankruptcy case, it's a federal court. I can't file it in state court. I can't file it if I live in Oregon, I can't file it in Utah. Has to be in Oregon. So bankruptcy is, for example, a court of exclusive jurisdiction. Only that court. Sometimes you have multiple courts that may be able to handle a case. So maybe, for example, somebody robbed a bank in Dallas, Oregon, and they drove their car across the bridge into Salem. And when they were in Salem, they ran into somebody, maybe a pedestrian, to get them out of the way. And then they ended up driving into a 7-Eleven and crashing through the front door. So we have a whole bunch of crimes going on that occurred in multiple counties. So that's one continuous stream. So in that case, the Polk County Court and the Marion County Court would both have potential jurisdiction. So that's called concurrent, where sometimes we'll have a situation where you have a case that could be filed either in federal court or state court. Either court has the authority to handle it, and then the lawyers decide which court they want to file. And I'll give you some example of that more in a little bit. So for now, exclusive jurisdiction, only one court in the whole U.S. can handle the case, like bankruptcy. Concurrent, more than one court. If you remember that, it's pretty simple. All right, so let's flip over to the next page now. This is where it gets a little bit more interesting. Okay, so at the top of the page, I have my little handwriting scribbles there. So now we know we have to find a trial court, original jurisdiction, to file our case. It may or may not be exclusive. That's yet to be determined. So that brings us to the jurisdiction equation. P, this is a plus, S equals J. Personal jurisdiction together with plus subject matter jurisdiction equals complete jurisdiction. So in order for a trial court judge, or this is true for appellate courts as well, but we'll focus on trial courts, because that's where I have to start. In order for a judge to have total jurisdiction, that is the authority to handle that case, I have to prove as the lawyer to the judge that the judge has both personal jurisdiction over the case and the parties, and subject matter jurisdiction. So, basically, personal jurisdiction is a geographical thing. Where on the map is the court located? What are the geographical boundaries that that court has authority? So if it's the city of Monmouth, it's the Monmouth city line. If it's a Polk County court, it's the boundary of Polk County, Oregon. If it's a state court, it's the boundary of a state. If it's a federal court, of course, it's the whole U.S., broken down, like I showed you earlier, into the various districts within each state. So the first thing I have to show to a judge is that the case and the people involved in the case, the parties, have a connection with the physical location of the court, the boundaries where the court has jurisdictional authority. So I have to show an attachment or a connection right here. A personal connection between the parties and the court, the location of the court. All right, so I have to show this connection. And this applies to everybody involved. So back to my map here. Again, We have the Oregon company, restaurant in Boise that caught on fire, equipment made in Michigan. People trucked it out are from Utah, or the construction were from Utah. The injured party's from Arizona. So the injured party filed a lawsuit in Arizona. So I'm now going to analyze that as the lawyer. I'm representing the owner of the restaurant. So first we have to determine, is Arizona the proper place to file a case that essentially started in Boise, Idaho? So the idea is I got to take a look at, all right, what are the connections with Arizona, with the parties? So first, the plaintiff who filed the lawsuit, they live in Arizona. So that's a connection. You live there. That's an easy one. But we also have to show a connection with the other parties. So the company that owns the restaurant, they're headquartered in Oregon. They have a physical location in Boise, Idaho, and in the state of Washington, California, but they don't have any restaurants in Arizona. They don't do business in Arizona. They really don't have any connection with the state of Arizona. So I'm going to make the argument to the judge in Arizona. I'm going to file a motion to dismiss, and I'm going to ask the judge to throw out the case in Arizona because the court does not have personal jurisdiction over the owner of the restaurant, because the owner of the restaurant has no connection with Arizona. Now maybe you visited there once and went water skiing or something, but that's irrelevant. It has to be a connection that's material. So the idea is the location for personal jurisdiction, there must be a connection between the court and all of the parties involved. If not, the court does not have personal jurisdiction. You filed it in the wrong place. Simple as that. So when I say connection, what do I mean by that? All right? So there are a number of different connections. The first one, probably the easiest one, is you live there. So I live in Oregon. The Oregon courts are going to have a personal connection with me. You reside there. You're here for school at the university, even though maybe you're a resident of Hawaii, but you come to school here at Western. So you have a connection with Oregon because you're a student. You do business there. So I have a storefront or a warehouse, or I sell goods, or I advertise in that jurisdiction, or I have whatever, some kind of business activity. So I live there, I reside there, I do business there, I do sales or whatever. Another one would be a contract. We entered into a contract in that location, and all the parties signed the contract there. But the best, I'm saving the best connection for last. And this is the first place as a lawyer you should always look for personal jurisdiction. Where did the event that led to the lawsuit occur? If it's a car wreck, where was the car wreck? Where did it occur? In our case, it's a fire at a restaurant in Boise, Idaho. So that is the location where we should start, because everybody involved has a connection with the location where an event took place. Right? I'm the owner of the restaurant that's located there. I'm the injured party. I was at the restaurant when the fire broke out. The construction contractor built the restaurant. Even though they're from Utah, they built it in Idaho. The manufacturer shipped their goods to Idaho. So everybody has a connection with, I think it's Ada County, they're in Boise, or the federal court, which is also in Boise. Everybody has a connection with Boise, Idaho. And so that's the first place you should always look to determine personal jurisdiction. Where did the event occur? That's the best. And you're thinking to yourself, okay, well, why don't you just always file the case where it happened? Well, there are reasons for that. Some states have different laws that may be more beneficial. There are other reasons for that, which I'll get into a little bit later. Strategy, okay? So long story short, back to my P plus S. The first threshold, when I'm looking at the map, I'm going to try to find a court that has jurisdiction and a connection with everybody involved. The plaintiff, the defendant, the companies, whatever the case may be. All right? So that's the first thing we have to look at. Now, what if it's Microsoft or Intel or Procter & Gamble? What states do they do business in? Every state, right? So, that connection, if you're doing business everywhere, you pretty much have personal jurisdiction all over the place. It's because you're doing business on even a global basis. All right, now we have to have plus. That's why I have and right here. I'm going to highlight and. Got to have both. Okay? So the first one, personal jurisdiction, is a location. The second component is subject matter jurisdiction. Subject matter refers to what type of case is involved. Is it criminal? Is it civil? Is it breach of contract? Is it bankruptcy? Is it a divorce case? Is it a name change? Is it adoption? Is it probate after somebody died? Is it small claims? Automobile accident? Whatever the case may be. So we have to look at what is the type of case, civil or criminal, and is it the type of case that that particular court has the authority to handle. So again, back to bankruptcy. Bankruptcy is a court of exclusive jurisdiction. So the subject matter is bankruptcy. So one, I don't file a divorce case in bankruptcy court. It may be the correct location, personal jurisdiction, but it's the wrong type of case for a bankruptcy court. So I have to file a divorce case in some other type of court. It's the wrong type of case for the bankruptcy judge to handle, and the judge will throw it out. Lack of subject matter jurisdiction. So I have to find both a court that has the location that is correct with connections to the parties, and it has to be the court that has correct subject matter jurisdiction. So some courts are very limited on the type of cases they can handle. Bankruptcy I've already talked about, but small claims is another example. Small claims can only handle cases up to $10,000. Depends what state you're in. In Oregon, it's $10,000 max. So if I'm going to sue somebody for $30,000, I don't file it in small claims. It's the wrong subject matter for small claims. So same thing with federal court. There are limits on the type of cases you can handle in federal court, which we'll get to in a moment. That has to do with federal subject matter. Is there a federal law involved for that kind of thing? All right, so I have to find a court that has both the location and the correct authority to handle that type of case. Now, some courts have very broad subject matter jurisdiction. Some courts have very limited, like tax court, very limited to tax cases only, okay? Now, how do you know? Well, there will typically be a statute that provides the subject matter for that type of court. It will either be only these type of cases, or it will be more expansive, like circuit court in Oregon is very broad subject matter. And it gets real technical from there, which I won't get into in this class. It's more law school. But I just want you to know, first of all, personal plus subject matter equals jurisdiction. If you do not have both, that is the wrong court. You have to go find the correct court, because that court does not have jurisdiction. So, trial court, jurisdiction, original jurisdiction, appellate court jurisdiction, exclusive jurisdiction, concurrent jurisdiction, it's on the page before. Personal jurisdiction